So I'm going to allow Marc to introduce and begin the panel on free culture medical technology. And he knows a lot more about the impressive resumes of the two gentlemen he's going to be interviewing, except I apparently went to college with George Contreras, but I don't remember actually talking to him, but we must have been in the same room many times. Marc, I have the great pleasure of having written 3 or 4 papers with Marc now, not academic papers, just essays. Marc is on the board of Public Invention, and is a staunch advocate for free culture in general, and open source things as well. He's an intellectual property attorney who is the general counsel for Civic Actions, a fiercely open government contracting firm. Take it away, Marc.
Thanks, Rob. So I want to introduce George Contreras and Joshua Sarnoff. George is a professor at the professor of law at the University of Utah. He's also an adjunct professor in the School of Medicine, mostly focused on patent law, or he's a patent attorney with a background in electrical engineering, which I think makes him uniquely qualified to speak to, I think, many of the people in our audience with an engineering background. And Joshua was a professor of law at DePaul University, who's also an intellectual property attorney, and similarly has a very diverse background. And I would love to read their entire CVs, because when I read them, was very impressed with the diversity of areas that both of them touch on. And that's kind of what I want to talk about today. So we're not going to talk so much about free culture medical technology, but you have 3 lawyers who are all intellectual property lawyers. So we're going to talk about policy and how legal policy affects the development of medical device technologies, particularly with a free culture lens. So George, I just wanted to start off with you because I knew you were heavily involved in the COVID-19 pledge, or the Open COVID-19 pledge. So can you tell us a little bit about what that pledge did and some of the challenges you encountered in creating that pledge and how successful you think it turned out to be?
Yeah, Marc, thanks very much. And thanks to Robert for inviting me. And it's great to reunite with you after many years in college together. So as everybody in this session undoubtedly knows, at the beginning of the COVID-19 pandemic, there were news reports about patents and IP posing barriers to the repair and the distribution of parts for ventilators and other equipment, as well as diagnostics and potentially drugs relating to COVID-19. So a group of academic lawyers, scientists, and engineers got together. There are 10 of us at the core to think about ways that we could help to eliminate some of that blockage or the barriers. During this time, there were companies like Medtronic and Smith Group in the ventilator space, but also the drug company AbbVie and a number of others who had unilaterally pledged their patents and design files to the COVID-19 response without charge. And we thought, well, maybe we could generalize what they've done to create an open framework for any companies or institutions who wanted to make their IP available in this effort. And so we created something that became known as the OpenCOVID Pledge. It's a simple statement that companies or institutions who have IP can adopt. And it operates like an open source code software license or like a Creative Commons license, in that you make this simple statement, you publish it on your website, you adopt it, and then there's a license behind it that's legally binding and enforceable. And in this case, the license says that whatever the patents or copyrights were that you contributed are available to anyone without charge to operate under in connection with the response to COVID-19. So we launched this in early April of 2020. And in the first month or so that followed, there was significant take-up, mostly from the tech side, not so much from the biopharma side. And we can talk about why in a little bit. But approximately 500,000 patents were pledged to this effort by companies like Microsoft, Intel, IBM, Facebook, Amazon, HP, Uber, A lot of big names in the tech space, as well as some smaller companies, a couple of public institutions like Sandia National Labs, the Jet Propulsion Laboratory, the New Jersey Institute of Technology. And it was a surprise how much technology was pledged in this open way for this limited purpose of addressing the COVID-19 pandemic. I can keep talking, but
that's great. Joshua, I was wondering, I know you and George know each other for a while. It's like, I just was wondering what your thoughts are on the success for the open COVID-19 pledge, and also specifically from your background, because I just found this fascinating when I first met you, from a moral perspective. Like, is this the right thing for intellectual property holders to be doing, to sign up for a pledge like this? And was this the right kind of pledge from a moral perspective, that the tech companies, especially that Jorge pointed, or that George pointed out, were they doing the right thing, and was this the right way to do it?
So let me pick up where George left off, which is that the tech companies, or many tech companies, did join the pledge, and most of bio and pharma did not. So we ended up sending a lot of public money to promote the biopharma development of treatments and vaccines. We've heard mostly about vaccines, much less about treatment. And there, the big question is regulatory approval costs. Clinical trials are extremely expensive. In contrast, for medical devices, the costs are significantly lower, but still not insignificant. So I guess the short answer is, in terms of, what obligations do companies have to assist with public needs in a pandemic situation? And there, we don't have very good standards in place. I mean, many of these companies, to their credit, chose to devote their intellectual property to open up the area for anyone to use to develop the needed, typically physical assets and devices, but very few of bio and pharma chose to volunteer in this way. George can say more about Moderna's pledge and what it invoked and didn't involve. But the real question is really one of not just the private action, but also of the government. What role does the government have in compelling the actions by private entities in the context of a pandemic? And there, we really haven't seen very much yet.
So
right.
George, a little bit about some of that private action, though, from the tech companies. Did you see the Open COVID pledge being used successfully? I mean, especially for this group, I think there's a lot of people here are interested in open ventilators, but was the pledge successful in allowing third parties to repair ventilators, which I think would probably be one of the conceivable goals you wanted? Or were there other successes around that, and the manufacturing in private space, which is where we saw the uptick in this?
Yeah, so a couple of things. So to ventilators specifically, one of the organizers, or a couple of the organizers of Open COVID pledge, are in the ventilator space, right? Especially people in the UK who are involved with helpful engineering, as well as the OVSI, the Open Ventilator Systems Initiative. They've committed their IP to this. And the ventilator space is one of the areas, again, I mentioned Medtronics and Smiths, which unilaterally pledged their IP and design files for particular ventilators early on in the pandemic. And I've got to think that has helped. One of the things, it's hard to track how these pledges actually are deployed and operate, because in most cases, we don't ask users to register or sign up or execute the licensing agreement, right? It's kind of like open source code, but with smaller traceability. At least software, you can, send bots out and search the web and see who's using your software, possibly, but with with patents you really can't. So there are two things that we're striving for. I mean, one is just achieving a critical mass, so that certain fields have the feeling of an open development space. I think that in terms of ventilator parts, after the initial kerfuffles with the Italian hospital back in March, I think that there's reluctance on the part of ventilator manufacturers to make too big a fuss about legally pursuing independent engineers who try to make replacement parts for their ventilators. And I think that they know, I think Medtronic and Smiths and others know that these independents aren't going to displace their sales of ventilator products to hospitals, right? I mean, there's the brand, there's liability considerations. So I think that they're not giving away their entire business yet, or doing the right thing by opening this up. But in other areas, so take contact tracing, for example. A lot of IP was pledged in the OpenCOVID pledge in the area of contact tracing. A lot of the IT and software companies have IP in this space. And so contact tracing is an area where a lot of independent app developers are springing up, and have sprung up all around the world, and have tried to help. I mean, people may or may not like the idea of contact tracing, assume it's voluntary and privacy is preserved. It's helpful in epidemiology and disease modeling. There hasn't been litigation around contact tracing. And I think one of the reasons is that most of the big companies that have IP in this area have stood down and said, let people do what they want. We're not going to sue in this area.
So that's interesting, but we're still just talking about COVID-19, right? Which, I mean, I think is also important to acknowledge too, that COVID-19 is still going on in the world now, that even for people on this call who are located in the US, we might be getting kind of relaxed, but like this is a real problem that's ongoing in the rest of the world too. Right? So access to this technology is it's not something that's passed, it's still an ongoing thing. But Joshua, I know you've thought about this too. George mentioned a couple of things like liability from companies and the scope of the Open COVID-19 pledge. Is this enough? Like, should we be responding to an emergency with the Open COVID-19 pledge, or should we be creating a framework around how to handle emergencies? And is that similar to a right repair for like your car, or is there something special about ventilators and contact tracing software?
There's nothing special about it, in the sense that the need for certain kinds of equipment in all kinds of emergencies exists. So the problem is that you can get agreement that when you have a pandemic that is widespread and affecting everyone, that people are going to be willing to forego making money, forego their rights. Government may choose not to enforce in order to help. But what about, for example, hurricane damage, and the need to generate things like emergency housing, medical needs around people who have been hurt by hurricanes. Again, we don't. Those should similarly be situations where, if there is a need to scale up manufacturing rapidly for particular needs, we should be able to do it. So, I've proposed creating emergency legislation that would allow the government in advance to create effectively, waivers of intellectual property rights by declaration in certain circumstances, but you're not going to get ex ante agreement very easily to adopt such legislation. So the short answer is, of course, it's not sufficient, but this is an area where something is better than nothing, and there was at least agreement to allow people to go forward in some areas. The area that most people have focused on as still being a potential problem, although it's less about patents and more about trade secrecy, is vaccines. We know that there is a massive worldwide shortage of vaccines. And the question is how to scale up production in an emergency, which we're in a way that also is protective of public health. That's an area where we don't have any agreement yet over
And
how to.
that's a great question. George, what about vaccines? And the Open COVID-19 pledge wasn't picked up by vaccine manufacturers. Maybe that's not surprising because that's their core business. But did you and the other designers of the Open COVID-19 pledge make the right balance in limiting the scope of the Open COVID-19 pledge to just COVID-19? And would you do anything? Would you do anything different when creating that now in retrospect, considering the people that picked it up?
Yeah, well, so there are a lot of design choices in this thing, and we did approach this project as a design project. And for those who are interested, I put in the chat a paper that we've got that goes through a lot of the design choices that we looked at when creating this pledge. I'm not sure that anything we could have done would have convinced the vaccine manufacturers to jump on board with this. I mean, I agree with Josh that in that case where there is so much money at stake, you're not going to have a voluntary, voluntary sign up by those companies. It's the companies who weren't specifically trying to monetize COVID-19 who signed up for the pledge. So take Microsoft or IBM. They have a lot of valuable IP. They've got huge portfolios, but they're not out there trying to make a business with respect to selling their technology or licensing their technology for COVID-19. That was the target of the pledge. Vaccine manufacturers, it would be great. And I don't even expect that the private companies would have signed up. It would have been great if universities, which are supposed to have a public charter, are supposed to be operating for the public benefit in most cases, if they had signed up and taken a less commercial view towards some of this, but even so, most didn't. So I'm not sure we could have gotten. I think some sort of government intervention had to be, would be necessary, as Josh said, to get some of those companies involved. Did we make the pledge too narrow? I mean, I think is your other question, is limiting it to COVID-19 too little? Maybe we were trying to address a particular emergency at a moment in time. We wanted companies to sign up. We didn't want to make this a general, access to medicines type of activity. There are lots of other diseases that even companies who have made pledges want to sell products with respect to. We thought COVID-19 was a specific emergency. Let us see if we can do something with this emergency, and then we could think about others. Next.
I mean, to me, that actually, it strikes me as the right thing to do, right? Because you were coming up with a pledge in the time of emergency and trying to get uptake, right? And the way our IP system is structured now, there's very little you can do to force an IP holder to do a good thing. So trying to create a pledge that entice people to make resources available quickly, because this is time sensitive, right? Like you need to respond to pandemics quickly, maybe more quickly than we were actually capable of. And I'm wondering, Joshua, I see you posted something in the chat, but we also had a couple questions too about, like, one person asked, another Joshua asked about weakening patent rights. What are some of your suggestions that we should be doing to change the intellectual property regime, or maybe not necessarily intellectual property directly, but the legal framework in general, so that we can, effectively respond to emergency situations in a moral way where IP rights holders are fulfilling, like, I don't know, specific legal duties, or at least a moral duty to society?
So there are any number of things that can be done. Getting legislative agreement from powerful interests when the argument is that weakening the intellectual property rights at all will interfere with our innovation infrastructure is going to be a real challenge. So just a few simple examples. The first one is rights of repair. We could federally legislate rights of repair across all of our intellectual property rights. Thanks. And we could legislate rights of repair across all of our intellectual property rights. This would, allow third-party manufacturers to make repair parts and to, allow very rapid increase in supplies when there is a need for them, such as, the ventilator parts that were at issue early in the pandemic. And again, this could be not limited to a declared emergency like COVID, but all sorts of situations. The second one, which I noted in the chat, is that the premise of the patent quid pro quo bargain is supposed to be that you disclose how to make and use the invention in exchange for an exclusive monopoly for a period of years. But we all know that in part by legislative changes to get rid of the best mode requirement, and because it has never required the disclosure in the patent of post-filing manufacturing know-how, that getting the patent rights is not in fact equivalent to putting the public in possession to be able to make and use the invention at scale. And therefore, it's trade secrecy, knowledge, and know-how that then become relevant. So we could simply change the legal requirements, impose, for example, an update requirement that in order to keep your patent, you have to disclose how to make and use at scale. At that point, compulsory licensing would become valuable and relevant, because then the legal authority to make and use by a third party would be possible, and the knowledge to do so is possible. The third and more difficult issue, and this has really come up now in regard to vaccines again, is to actually compel know-how transfers among companies and among the public in order to scale up where there is excess production capacity. So you guys are thinking about how to scale up oxygen generators. The question is, why can't the manufacturers transfer the know-how that they already have to make that production more widespread, more affordable all around the world? And the question, that's just a question of our legislative will to change the private reliance on the market system. But again, you'll confront the narrative that doing so interferes with our entire innovation ecosystem. It'll then deprive funding from investors to innovative companies. They will no longer make the pioneering goods and services that everyone wants. So this is a battle of narratives more than anything else.
So George, what about that idea that government, I think a lot of the legal regimes, government changes that Joshua just mentioned do make a lot of sense, but you have experience talking about an open pledge from the private sector, which as an intellectual property attorney who focuses on open source licensing, I would not call free culture or open source because the scope is so limited. But I understand why you were doing it for a point in time. But with that experience and hearing some of the suggestions from Joshua, if you wanted to create a licensing policy or an open pledge that organizations like Public Invention are interested in having, or Helpful Engineering interested in having, where we're not trying to protect our core businesses. Our core businesses are to share the knowledge of other people. What lessons would you draw from the Open COVID-19 pledge where you might, ask for more or, get some of that knowledge transfer requirements around you?
Yeah, the knowledge transfer is tough. I mean, if I were putting together a new sort of pledge or licensing program from scratch for the programs that you mentioned, it would be different than the Open COVID pledge. There have been lots of pledges, right? This is not the first one. They go back, a good 3 decades to the 90s, at least in the open source world, right? Where companies like Sun Microsystems and IBM pledged their patents and said they wouldn't bring patent claims against people implementing Linux. But we've seen these in a lot of places, and they work differently. And sometimes they're very broad, You've got all sorts of pledges that say that you won't assert your patents against any company with fewer than 30 employees, to help out small businesses. They run the gamut. So the COVID-19 scope limitation, that seemed appropriate for the time, but, it was a special purpose program. It certainly could be broader. And, we are seeing in areas like climate and sustainability, there are pledges that are popping up in the industry that are, that are broader than the COVID pledge. I mean, I do agree with Josh, right, in that government intervention is undoubtedly necessary in, in some of these cases. And one thing that I'll throw in that we haven't mentioned yet is, as far as the incentives to innovate in this area, the biggest incentive for companies in the pandemic has been the government procurement dollars. Moderna didn't need patents at all, given the $2 billion that the government paid it for the first 200 million doses of the vaccine, right? I mean, that $2 billion more than helped it recoup its R&D costs. And so it's entirely possible, and no government has taken advantage of this yet, entirely possible to attach strings to procurement dollars. You don't need to change the law. You don't need Congress to amend the Patent Act, which, yeah, it could happen, but that's difficult to do. It could be the CDC or whichever agency, public health service that's buying these vaccine doses could say, oh, and by the way, as a condition to our paying you $1 billion for this first 100,000 or 100 million slug of vaccines, is that you will enable other manufacturers to also jump in and supply, doing whatever you have to do. And if you've got to pay your chemical engineers to go help somebody else put a factory in place, well, use some of that $1 billion to do that, because you've got money to spare now.
That is an excellent point, George. I think we're going to have time for one or two questions. Oh, we did get one question earlier on, which was a general question about can you share how you define the law, a code submitted to, or the way people define our collective rule? And I'm just going to respond to that quickly. I think I can do this, is asking a law professor how to define the law might result in a very long answer, but I think lawyers generally mean the law is any kind of rule that you have an obligation to follow. So it could be statutes passed by governments, it could be regulations passed by government agencies, which might actually be rules about how procurements that George just mentioned there. It could be, even private agreements in some cases have the feeling of a law. So it's generally rules that you're trying to follow.
And backed by force. I just want to add one more thing to what George, or two more things to what George said. Pfizer generated the vaccine by using without authority some technology that was patented. There aren't actually patents on the vaccines themselves. It's the inputs that were the issue. And there, they just ignored the fact that they were patented, partly because we have exceptions from infringement. So there's a lot that could be done by expanding those exceptions from infringement, at least for the R&D stage. And George and I have both written about the experimental use exception and expanding it. More importantly, though, the government is not just a purchaser. The government is the one who is the initial funder of much of the research. And the government in these cases, for both treatments and vaccines, expressly not only refused to impose statutory requirements to retain rights over these inventions, but it actually wrote in its contracts that it would not exercise authority to authorize third parties. That's just offensive government action. The government could have done exactly what George is saying, we're going to pay you to develop it. We're going to either own it ourselves, purchase it, use our government license to authorize third parties for free because this is a national emergency. There's number of things the government could do without any change to the law at all, with a willingness to confront the narrative that this will diminish long-term innovation by interfering with private rights.
Thanks. I'm not seeing any questions in the chat right now, although I know this question often comes up when I'm speaking with groups about intellectual property. And we haven't discussed that before, but I guess Joshua, to you, because I'm so interested in your academic past, is should intellectual property rights even exist? Like, should we have patents? Is the answer to this that we should get rid of patents, considering all the problems that you've mentioned today?
I think the answer is you do need patents for some things, and particularly we need to think about how we fund clinical trials. I would like to see the government fund them directly and have more control. Then you don't need massive expenditures by pharma to recoup the costs of failed clinicals for second use or second drugs for the same indication, but we could actually invest the money sensibly. Going back to the history, though, I've written about this, we shouldn't have patents on discoveries of nature. That's, I think, immoral under Lockean property theory, as well as religious conceptions that this is God's world free for all. That's not to say that where there is human-made invention, we shouldn't allow patents for certain kinds of creativity, but it's much more limited than where we've been and certainly where we're heading, although thankfully the Supreme Court reimposed to some extent limits on this in regard to gene sequences and certain kinds of physical discoveries. But this is exactly where the narrative gets joined right?
It's a hard question because it is a big question, but thank you for explaining that in such a concise way, because that help bringing it back to the original purpose, I think, is such an important thing to keep in mind about where these legal regimes came from and like why we created them, and remembering the balances we should be striking. I think that's it for our panel. So I just want to thank you, George and Joshua, for participating. It's probably the most interesting panelist that I've ever had the pleasure of moderating before. So I'm going to pass it back to you, Rob.
Okay, thank you. I would like to thank George and Joshua again. Thank you. I would love to talk for another hour on that subject, but we're going to go right into some additional very important talks